he passed away. Last year, the award was given to Judge Janice Rogers Brown of the D.C. Circuit, and this year to my friend, Judge Bea. Judge Bea has a wonderful, wonderful background, and I'll tell you a little bit about him. He's a judge, as you know, on the Ninth Circuit Court of Appeals. And and I just have to sidetrack a little bit. As district judges, we are invited pretty often to sit on the circuit. And we always, some of us want to know who we're going to sit with. And if it's judges that maybe philosophically we don't agree with, or for other reasons, we say, no, thank you. And unfortunately, I never had the pleasure of sitting with Judge Bea, and it would have been fun because I think we think alike. And so I regret that I never had that opportunity. Judge Bea graduated from Stanford University, and again, something we have in common, in 1956. In 1958, he graduated from Stanford Law School. He was born in Spain, in San Sebastian, Spain, and immigrated with his family to Cuba in 1939. In 1952, he represented Cuba on the Cuban national basketball team. Now, I thought Cubans played baseball, but he was at the Helsinki Olympics in, what year was that, 1952, on the Cuban national basketball team. He became a naturalized citizen in 1958. He was engaged in private practice in San Francisco, principally in the area of civil trials, jury and non-jury. And from 1959 to 1975, he was at the firm of Dunn, Phelps, and Mills. And from 1975 to 1990, he was at his own firm, the Carlos Bea, a law corporation. He taught courses in civil litigation, and advocacy at Hastings College of Law, and at Stanford Law School. From 1990 to 2003, he served on the Superior Court in San Francisco. He was nominated by George W. Bush to the United States Court of Appeals for the Ninth Circuit and was confirmed in 2003. Tonight, my husband and I have had the pleasure of meeting his lovely wife, Louise, and they live in San Francisco, where they've raised 4 sons, Sebastian, Alexander, Nicholas, and Dominic. Do I have the names correct? And so it's with great pleasure that I introduce Judge Carlos Bea.
Thank you, Irma, and thanks for inviting Louise and me to San Diego to this wonderful, large gathering of the Federalist Society. A disclaimer first. Yes, I played on the Cuban Olympic basketball team in 1952, but I consider myself an Olympic tourist because we went 2 and 5. Our son Sebastian is an athlete. He won a silver medal for the United States in 2000 in the Sydney Olympics in the men's pair. So tonight, what I hope to convey to you is the effect which Justice Scalia's tenure on the court had specifically on judges like myself who share his judicial philosophy, and also on judges who did not. Before Justice Scalia took a seat on the Supreme Court in 1986, the Supreme Court's approach to the interpretation of statutes looked very different than it does today. Consider Justice Thurgood Marshall's views on the matter. After Justice Marshall found that the legislative history of a statute was ambiguous, he famously stated the following: because of this ambiguity in the legislative history, it is clear that we must look primarily to the statutes themselves to find the legislative intent. Imagine that, actually reading the statute for content. You heard that right. Justice Marshall looked at the legislative history of a statute before reading its text to construe the statute's meaning. Justice Scalia turned Justice Marshall's approach upside down, or, as I see it, right side up. A few years ago, Justice Kagan, while speaking at Harvard about Justice Scalia's impact on statutory interpretations, declared, "We are all textualists now." To the more recent members of the bar, Justice Kagan's words may not seem terribly profound. Of course, any competent lawyer knows that when construing a statute, one begins with the text. I can assure you that this was not always the case. For those of us who remember a time before Justice Scalia, Justice Kagan's statement is a testament to the sea change the law has undergone in recent decades as to the interpretation of the Constitution, statutes, and even documents. Let me begin with the Dark Ages, an era in which it was difficult to call oneself a judicial conservative openly. For decades, law schools have been hostile to conservative legal thought. Things haven't changed much. Professors who held such views learned to keep them to themselves. As a result, law schools tended to produce lawyers who believed in an active role for the judiciary. Such was the legacy of the legal realists and their intellectual heirs, who argued that judges do not in fact decide cases in accord with the law, not because judges are willful or incompetent, but because the law itself is radically indeterminate. This thinking laid the groundwork for the rise of the so-called purposivists. According to such thinkers, every law had a purpose aimed at addressing some social need. It was the task of the judge, acting as the legislature's partner in lawmaking, to ensure that such purposes were carried out. This mindset empowered judges to break free from the constraining bonds of the statutory text to ensure that a preferred public policy was achieved. As Justice Scalia famously declared in his book, The Matter of Interpretation, our law schools made common law lawyers of future judges who believed it was the role of the judiciary to make law and not merely to interpret it. And so when it came to applying the law, judges were, for the most part, guided by policy, not text. These common law judges felt comfortable going beyond the text of the Constitution to resolve a large number of constitutional questions that were previously left to the other branches, to the political process, or to the states. Whether it was policing the equality of congressional districts or scrutinizing Congress's exercise of the 14th Amendment enforcement authority, courts felt empowered to involve themselves in an expanding array of constitutionally significant disputes. The late Justice William Brennan used to hold up one hand, fingers spread, to illustrate what he called the most important rule of constitutional law, the rule of 5. With 5 votes, the justice can do anything. Needless to say, the original understanding of our founding documents carried little weight under such approach. Of course, all this was precisely the approach to judging that Alexander Hamilton, in Federalist 78, had warned against when he wrote, "The courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. But to ask what the founding generation may have thought about a question of constitutional interpretation was to identify oneself as an outlier, a pariah, a fringe legal thinker not competent for the bench. To assess what strides Justice Scalia gave to textualism and originalism, one need only read his opinion and Justice Stevens' dissent in D.C. District of Columbia versus Heller, the case in which the court arrived at a finding of an individual right to keep and bear arms under the Second Amendment by a textual and historical analysis. Justice Stevens disagreed and dissented, but again based his own reading of the text on history. Although I credit Justice Scalia for shifting the courts toward the more limited role envisioned by the country's founders, I always disagreed with him on one front. Justice Scalia was an early and ardent proponent of the Chevron doctrine. A refresher for those who do not remember the Chevron doctrine from their administrative law classes and those who didn't take law classes at all. In Chevron versus Natural Resource Defense Council, known colloquially as Chevron, the Supreme Court decided what standard federal courts should use when reviewing an executive agency's interpretation of a congressional statute. Chevron created a two-step test. First, the court must determine whether Congress, quote, has directly spoken to the question at issue, unquote. In other words, whether a statute is unambiguous or silent with respect to the precise issue before the court. If the statute is unambiguous on that precise issue, then that is the end of the inquiry, for the court, as well as the agency, must give effect to the unambiguously expressed intent of Congress. But if the statute is ambiguous or silent with respect to the specific issue, the court asks whether the agency's interpretation of the ambiguous provision of the statute is reasonable. If the agency's construction is reasonable, then the agency's interpretation is afforded deference by the court. Justice Stevens, who wrote the opinion in Chevron, justified deference to agency interpretation primarily because the agency had expertise. This was a reflection of Herbert Crawley and Woodrow Wilson's admiration for non-political experts. It was later that Professor Buchanan, who would win a Nobel Prize for economics, developed public choice theory. That is, that far from being impartial, administrators acted based on maximizing their own utilization. When Chevron was first decided, Justice Scalia did not share my concerns about the Chevron doctrine. He thought it effected political responsibility onto the executive for agency action. I disagree with that view. As a practical matter, the bureaucracy seems immune from political responsibility, especially since the executive describes agency actions as being taken for impartial and professional reasons. From my perspective, Chevron and its progeny have transferred the core judicial function to say what the law is to executive agencies. No doctrinal or practical justification supports this encroachment on our system of separation of powers. From a doctrinal point of view, I've never understood what principle allows an administrative agency to interpret legislative language when the legislature itself cannot do so other than through the enactment and presentment of a new law. How can one delegate a power that one doesn't possess? From a practical point of view, I've not understood how civil servants can more accurately determine what the law is than courts, who have been charged with that duty from the time of Marbury versus Madison through to the enactment of Section 706 of the Administrative Procedure Code of 1946, both of which are still on the books. However, as the administrative state increasingly began to encroach on the role of the judiciary to interpret laws and the role of Congress to make laws, Justice Scalia began to recognize the harmful impact of the Chevron doctrine. Consider his dissent in the Brand X case, a case where the Supreme Court held that an agency's interpretation of a statute trumped a federal court's interpretation of the same statute, unless the federal court had previously held that the statute was unambiguous. Justice Scalia strongly disagreed with the holding in Brand X, stating that, quote, when a court interprets a statute without Chevron deference to agency views, that is, without the benefit of any previous interpretation of the statute, its interpretation is the law. Justice Scalia's dissent comports with the well-known axiom pronounced by Chief Justice Marshall in Marbury versus Madison. Quote, it is emphatically the province and duty of the judicial department to say what the law is. You also see Justice Scalia's frustration with our deference, a rule that grew out of Chevron's deference, which states that an agency can write imprecise rules, interpret those rules, and then demand judicial deference to its interpretation, in cases like Talk America and Perez versus Mortgage. The question whether Justice Scalia's views on statutory interpretation and the Chevron doctrine influence the judiciary may seem like an arcane topic. But Justice Scalia's position on the Chevron doctrine near the end of his life likely impacted the views of Justice Gorsuch, a vocal critic of the Chevron doctrine. Indeed, Justice Gorsuch, Justice Scalia's successor, was on the court. When he was still a judge on the 10th Circuit Court of Appeal, penned a concurrence to his own decision in the case of Brizuela versus Lynch, which excoriated Chevron and its progeny in no uncertain terms. In that case, the 10th Circuit had ruled on an interpretation of an, quote, ambiguous statute, and the Board of Immigration Appeals changed its interpretation of the ambiguous statute in a way which conflicted with the 10th Circuit's ruling. It was Brand X all over again, the agency trumping the court. In Brizuela, the BIA attempted to go a step further and apply its new interpretation of the statute retroactively to the petitioner before it had made the interpretation. The petitioner had been relying on the 10th Circuit earlier ruling. The 10th Circuit ruled that the BIA's new interpretation could not be applied retroactively, and Justice Gorsuch took the opportunity in his concurrence to make his views on Chevron clear, and he does not disappoint. Justice Gorsuch wrote that if cases like Brand X don't qualify as an unconstitutional revision of a judicial declaration of the law by a political branch, I confess I begin to wonder whether we've forgotten what that might be. He went on to describe Chevron as a judge-made doctrine for the abdication of judicial duty, and to warn the Chevron and Brand X allowance of executive agencies to take on judicial function invites the very sort of due process and equal protection concerns the framers knew would arise if the political branches intruded on judicial functions. Justice Gorsuch reminds us that we managed to live with the administrative state before Chevron, and we can do it again. So what exactly will Justice Scalia's legacy be for judges such as myself? It is the knowledge that we are no longer outliers, jurists on the fringe. Originalism, textualism, a more traditional view of the judiciary's role in our system of government, these notions have become the mainstream. Indeed, as Justice Kagan's words at Harvard demonstrate, the current generation of jurists has wholeheartedly embraced much of Justice Scalia's approach to judging. We also see how his rebukes of the Chevron doctrine and the ever-expanding administrative state, voiced near the end of his time on the Supreme Court, influenced a generation of judges, including Justice Gorsuch. Justice Scalia will be remembered not only for his humor and brilliance, but also for his tremendous impact on the minds of our nation's judges. Thank you very much.
Okay, that concludes our program. Thank you all for coming. There's a box over there for name tags if you care to discard them. And see you all next time.